Assist Public Defender Dobbie leave with Mr. Watkins. Mr. Watkins, you call the court, please.
Harold Watkins.
All right.
Here's the forms.
What are we doing?
Your Honor, we do have a plea agreement. I reviewed these forms, the advice rights and plea agreement with Mr. Watkins. He's signing them right here.
Let my staff know.
Unfortunately, I did not, Your Honor.
And Your Honor, that's partially my fault. I was to
No cover for legal.
one that I wanted to get this.
That is.
I apologize, Your Honor.
Still legal is fine.
Absolutely, Your Honor.
On-
I can tell the court what the plea is.
Sure. Well, that's a form coming in.
Very good, Your Honor.
Did you state your name, sir?
Harold Watkins.
I have before me the plea form that indicates that the defendant is going to be pleading to the stated count 2 of operating with the presence of a controlled substance, the 93-day offense, and also an added count 4 of use of cocaine, the 1-year offense. Upon a successful plea to those 2 charges, well, no, something's wrong. The form indicates that count 1 and 4 would be dismissed, but that's not right. It's
It
1
should be
and
1 and 3.
3.
My apologies, Your Honor.
Counts 1 and 3 would be dismissed. That's the court's full understanding of the agreement.
That is our understanding as well.
Likewise, Your Honor.
May I have him sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Harold Watkins.
Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Correct.
First charge is the stated count 2 of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. So you understand that?
Yes.
All right. And also that you be pleading to an added count 4 of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand? Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes.
Still wish to plead guilty
Yes.
to the charge of operating with the presence of a controlled substance? How do you plead?
Guilty.
To the charge of use of cocaine? How do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question regarding any of those rights?
Oh,
Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses? May 18, 2020, at the location of Adams near Catherine, city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested cocaine?
Yes.
All right. Were you stopped by the police?
No.
Was there an accident?
No.
What happened?
I pulled the car over and parked and went to sleep in the car.
Okay, you pulled the car over when you were asleep in the car.
Right.
Was the car running?
Yes.
All right. Police arrived at some point,
Yes.
woke you up,
Yes.
took you to the hospital.
Yes.
Was there a blood draw?
Yes.
And did that blood draw result in showing in your blood, your blood, either cocaine or its derivative?
Yes.
Do you have any reason to dispute those blood test results?
No.
All right. And at the time you used the cocaine, you knew what you were using was cocaine.
Yes.
Sir, I do have to apprise you that if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir? Yes. All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
Have I complied with?
Yes, Your Honor.
Court will accept the defendant's counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 6th at 10 a.m.
May 6, 2026, 10 a.m. before Judge Barr.
Thank you, Your Honor. And if I could respond,
Pardon?
may I respond? Thank you, Your Honor. Mr. Watkins tells me that he could stay at an address in Ypsilanti with his sister. We have no objection to GPS tethered to assure his appearance. He tells me that he regrets his previous failure to appear and that he had returned to Michigan with the intention of resolving these matters when he was picked up at a traffic stop, and that he will stay in Michigan until they're resolved.
I'm going to deny any request for a change of bond given the failure to appear, but also I'll leave that to Judge Barr's wisdom after there's an assessment on the case.
Thank you, Your Honor.
Time it's denied.
Public Defender Duffy, leave before Mr. Taft.
Name, sir.
Justin Taft.
Thank you.
Your Honor, we're going to be requesting adjournment in this matter. He has some other matters out of Genesee County. His attorney there is trying to get him into that veterans court program. And once we have an answer there, I'm going to be attempting to see if we can resolve the matters together.
Okay, I get you. But how long is that? Do they indicate the process? Because he hasn't been screened.
They indicate to me it'll be about a 30-day process.
This is the only thing holding him here?
It is, Your Honor, and I was going to request a release to treatment.
Are the people going to have any objection to a release to treatment?
Your Honor, this time I would. He originally failed to appear in 2022 and was gone on bench warrant for several years. And now is back before Your Honor with 2 new cases in Genesee County. I have concerns about him coming back.
What are the other cases in Genesee?
That I don't know. I can certainly find out. Now he has indicated to me that the VA has told him, and they've indicated this to our office as well, they would have a bed for him at a residential treatment facility in Detroit.
All right. Well, what I'll do is I won't authorize it now, but I'm gonna put this out. If between that time the parties could talk, because obviously he needs treatment. And I understand he'll get that in the veterans court if he's accepted, but if we can start that process earlier, I think that might be a better thing.
I agree.
All right. So I won't order it at this point, but I advise the parties to talk. And if the defense believes that there can be certain safeguards placed on and he's at the VA, you can file a motion for the court if necessary.
Thank you, Your Honor.
All right. Sir, what branch?
Army, sir.
Army. I won't hold that against you. All right. Shay wants 30 days out. Is that? I'm doing. May 21st. (2026) at 9 a.m. This bond will continue with this. Next, sir. Court calls case People versus Quinte Jenkins.
Apologies, Your Honor. I did not hear the name I thought I heard. That's Public Defender Davi Leba for Mr. Grayson.
Mr. Grayson, can you state your name?
David Grayson.
Sir.
And Your Honor, there is a new case. I've been advised that we're going to be waiting to catch up.
It's your waiting to catch up.
So I'm requesting to adjourn to wait to catch up.
Okay. Anybody have any other information on that for me?
I will pull it up here momentarily, Your Honor.
I've been advised that it's some sort of property crime, but I don't know any further details.
That's a big category.
It's authorized it last Friday, so I will follow up with the Sheriff's Department to be a bond violation.
Pardon?
It is not going to be a bond violation, but it
Got
is.
All right. So let's see if we can get those together. If they happen to get that, what I'll do is I'll set this for May 7th. So, right, 2026. 9 AM. All right. And so therefore his bond will continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Patrick Rowe.
Can you please state your name for the record?
Patrick James Rowe.
Your Honor, we'd be requesting an adjournment for further discussions with the people.
Just the only thing holding it.
Yes, Your Honor.
Probable cause conference will be adjourned May 7th. 2026, 9 AM. Bond continued.
Thank you, Your Honor.
Court calls the case people versus Eric Jackson.
Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Jackson.
Your name, sir?
Eric Jackson.
Thank you.
Your Honor, we are asking for an adjournment from Mr. Jackson for ongoing negotiations.
Adjourned the matter May 14th, 2026, 9 AM. Bond continued.
Mr. Jackson, May 14th. Thank you. Not yet, Judge. I'll be here till 2:00.
Joy.
This is just
Judge, you're asking for an adjournment. We just have to review some video footage with our.
Turn it to May 14th, 2026. Bond continued.
Thank you.
Sir.
Okay.
Court calls the case people versus Harold Watkins.
People.